Welcome back, future criminologists. In this video, I will be discussing preliminary investigation. Preliminary investigation. Preliminary investigation is an inquiry or a proceeding, the purpose of which is to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Nature of the right to a preliminary investigation. The right to a preliminary investigation is a mere judicial inquiry or inquisitorial. Thus, it is not a trial. The holding of preliminary investigation is not required by the Constitution. It is not a fundamental right and is not among those rights guaranteed in the Bill of Rights. The right is of statutory character, but a preliminary investigation is a component of due process in criminal justice. Purpose of preliminary investigation. Its purpose is not to declare the respondent guilty beyond reasonable doubt, but only to determine whether or not a crime has been committed and whether or not the respondent is probably guilty of the crime. And if there is probable cause, the prosecutor files the corresponding information in the court. Waiver of the right to preliminary investigation. Preliminary investigation, being a personal right, can be waived expressly or by implication. The right to a preliminary investigation may be waived for failure to invoke the right prior to or at the time of the plea. Now we go to probable cause in preliminary investigation. Probable cause is the existence of such facts and circumstances that would lead a person of ordinary caution and prudence to entertain an honest and strong suspicion that the person charged is guilty of the crime, subject of the investigation. Probable cause is based merely on opinion and reasonable belief. It does not import absolute certainty. The determination of the existence of probable cause lies within the discretion of the prosecuting officers after conducting a preliminary investigation upon complaint of the offended party. In the determination of probable cause, the complainant need not be present at this stage. Kinds of determination of probable cause. There are two kinds. First, executive determination of probable cause, and second, judicial determination of probable cause. Executive determination of probable cause. It is a probable cause made during preliminary investigation. The executive determination of probable cause is a function which pertains to the public prosecutor, who has the quasi-judicial authority to determine whether or not a criminal case must be filed. Executive determination of probable cause is the subject of preliminary investigation. Judicial determination of probable cause. It is a probable cause made by the judge to ascertain whether a warrant of arrest should be issued against the accused. The judge must satisfy himself that based on the evidence submitted, there is necessity in issuing the warrant. Who may conduct preliminary investigation and determine existence of probable cause? the following are authorized to conduct preliminary investigation. 1. Provincial or city prosecutors and their assistants. 2. National or regional state prosecutors. And 3. Other officers as may be authorized by law. The authority of the above shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. Judges of the first-level courts are no longer allowed to conduct preliminary investigation. The following may also conduct preliminary investigation. First, under the Omnibus Election Code, the 𝐂𝐫𝐿EC through its duly authorized legal officers involving election offenses. 2. The Office of the Ombudsman has the authority to investigate and prosecute on its own or on complaint by any person, any act or omission of any public officer or employee, office or agency when such act or omission appears to be illegal, unjust, improper, or inefficient. 3. The PCGG with the assistance of the Office of the Solicitor General and other government agencies. Cases that requires preliminary investigation. Cases that requires preliminary investigation are offenses where the law prescribes a penalty of at least 4 years, 2 months, and 1 day without regard to the fine. So, to determine whether the crime committed is subject to preliminary investigation, we should check first what is the imposable penalty for the crime committed. Exceptions or instances when preliminary investigation is not required. 1. Those with lower penalty, lower than 4 years, 2 months, and 1 day. 2. Cases falling under the rules on summary procedure. 3. Special laws which provides that preliminary investigation is not required. 4. Cities whose charter requires preliminary investigation. 5. Person arrested lawfully without warrant. In case of person arrested lawfully without warrant, inquest or summary investigation is conducted to determine whether he should remain under custody and then be charged in court if there is probable cause. I will discuss inquest in a separate video, so subscribe to be notified for our upcoming videos. Next, there are 2 ways of initiating the criminal action in cases where preliminary investigation is not required. First, by filing the complaint directly with the prosecutor. And second, by filing the complaint or information with the municipal trial court. Now we go to the first, by filing the complaint directly with the prosecutor. The prosecutor shall act on the complaint based on the affidavits and other supporting documents within 10 days from its filing. The prosecutor is obligated to conduct personal examination of the affiants and corollary to certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. Second way, by filing the complaint or information with the municipal trial court. In this case, the judge shall personally evaluate the evidence or personally examine in writing and under oath the complainant and his witnesses in the form of searching questions and answer. If within 10 days from filing, the judge finds no probable cause, he shall dismiss the case. If the judge finds probable cause, he shall issue a warrant of arrest, If the accused has already been arrested, the court shall instead issue a commitment order. The court may issue summons instead of warrant of arrest if there is no necessity in placing the accused under custody. Effect of absence of preliminary investigation on the jurisdiction of the court. Absence of preliminary investigation does not affect the court's jurisdiction over the case, nor does it impair the validity of the information or otherwise render it defective. In case there is an absence of preliminary investigation, a motion to quash is not the proper remedy, and thus the court should not dismiss the information. The court should remand the case to the prosecutor so that the investigation may be conducted. To end, please subscribe to our channel and stay tuned for more videos.